All rise. Hear ye, hear ye, hear ye. The Honorable Supreme Court of the State of Nebraska is now open for the transaction of business. Draw nigh, all ye having business with this honorable court, and ye shall be heard. God save the State of Nebraska and this honorable court.
Thank you. You may be seated. Good morning to everyone. We will begin with introductions from the court. I'm Mike Havican, the Chief Justice, and now, by order of seniority as to service on the court, the other members of the court will introduce themselves.
Good morning, I'm Lindsay Miller-Lerman.
William Castle, good morning.
Stephanie Stacy, good morning.
Good morning, Jeff Funk.
Jonathan Papik, good morning.
And John Freidenberg.
Thank you, members of the court. Our first case of the day is State versus Trail. Mr. Murray, you are here with us this morning. Good morning, and you may approach. And Mr. Smith, you're here. Do either counsel have any questions before we begin?
No, Your Honor.
Both sides are allotted up to 20 minutes. And you may proceed.
Good morning, Mr. Chief Justice. May it please the court, opposing counsel. My name is Ben Murray. I am the court-appointed attorney for the appellant Aubrey Trail. This is a mandatory appeal pursuant to 29-25-25 as it is a capital case. Mr. Trail was convicted of first-degree murder, conspiracy to commit that murder, and improper disposal of human remains. He was sentenced to death plus 52 years. So in my brief, I essentially fired every arrow in my quiver. I alleged a lot of errors, but would like to focus on the errors that are fact-specific to this case rather than some of the more general arguments that this court has contemplated before. I'd like to provide a little bit of background. As the court may be aware, this was a very public case. There was a lot of press coverage. There was a lot of public interest. We had a victim who at one point had been missing for several weeks. We had a defendant and a co-defendant who were then on the run. And while they were on the run, they were releasing videos and while they were being chased by the FBI. We have the defendant, Mr. Trail, who is the leader of a group of young women who were involved in theft, fraud, witchcraft, sorcery, torture. We also had an interesting twist where the luring of the victim was done over social media, which was kind of a new issue that we were dealing with. So that caused a lot of national press coverage. We had a full courtroom most days. We had people holding signs across the street picketing that the jurors had to walk by every day. And counsel had people filming us even as we came to and left our hotel every morning and followed us to the courthouse. So the jury was death qualified over our objection, and in voir dire they were informed that there was going to be talk of torture, of witchcraft, of vampires, unusual sexual practices, and even of the possibility that the victim's blood, they had drank the victim's blood. We also then, after jury selection, had a client who refused to come to court and was waiving his appearance for most of the first week. So that was another interesting twist. Then we get to the first day of the second week, and between witnesses, Mr. Trail stood up, yelled, "Bailey is innocent," Bailey being the co-defendant, "Bailey is innocent, and I curse you all," to the courtroom and the jury. He produced a razor blade that had been hidden in his mouth, and he sliced his throat. The security video, which was entered into evidence later, showed that the jurors were running and covering their faces, and so there was no question that they saw it. We later learned through deposition that this only happened, well, he only had the razor blade in the courtroom because the law enforcement hadn't followed any of their protocols. They hadn't searched him, they hadn't been searching him, and essentially the one person in the room who had admitted to murdering someone and dismembering them is the one person that didn't go through a metal detector, while all the rest of us did.
There was never an argument that the jail staff or the security staff encouraged him to do this, was there?
No, but
the argument was that they negligently allowed it to happen, but they never put the idea in his head or encouraged him to do it.
No, that you're correct. I think that it was more negligent because he had also given some warnings that morning that, hey, I'm going to wear my white shirt so the blood shows up, in the context of he said someone was going to shoot him in the head. So we made that argument in our motion for new trial because at the time we made the motion for mistrial, we had no idea that, I think everyone just assumed that he was going through security because we all were. So yeah, it wasn't that they were encouraging it. It was that, yeah, that either through laziness or whatever, they weren't following any of their protocols.
But you would agree that's an important distinction, isn't it?
It is, except in that in a lot of the case law on the mistrial, the cases say that, essentially a defendant cannot cause his own mistrial, but I think in one of the cases that the court relied on, I think it was Blackman maybe, that the district court relied on, it said it was solely caused. It was completely caused, completely his own doing. Well, in this case, that isn't true. It was true that the outburst was completely his own doing, but the fact that they had given him a razor blade 3 days earlier and hadn't taken it back, which they did with apparently every other inmate, we thought at least they played some part in it, but we'd agree it was negligent.
Was Mr. Trail in a wheelchair?
He was. So he was in a wheelchair, and they had stun belts on him, but for whatever reason, they didn't fire it when he stood up. I think part of that is just because we were between witnesses and it was kind of a down moment. It was not the most exciting part of the trial. I think we were between hotel employees who had seen him when he was on the run. But on our motion for mistrial, we relied on a Seventh Circuit case, the U.S. v. Manny, that just says, essentially, where are we at? Certain courtroom situations are so beyond the pale, so prejudicial, that no amount of voir dire and cautionary instructions can remedy the defect. And that's what we think we had here. The state in its brief says, they describe this as Mr. Trail standing up, stating, Bailey is innocent and I curse you all, followed by Trail making slashing motions to his neck with an object that resulted in some blood. Well, I admire their gift for understatement, but this was a lot bigger than that. I mean, it led the national news, all the networks, the cable news. This was a more dramatic experience than that.
How is a court to handle that situation?
I think
is it just automatically a mistrial, and now we're at the whim of what the defendant can think about to make it an egregious situation, or do they have to try to manage the situation and voir dire through the witnesses and things like that? Are the jurors?
I think the court has to try to manage it. The problem is, it was just so beyond anything. I mean, we're in a situation where we're talking about witchcraft, we're talking about torture, we're talking about this horrible murder, and they see this man make a suicide attempt, and on top of that, he is cursing them, whether or not these people believe in witchcraft or whatever. It makes it a little more impactful that he has cursed them.
But did you interview all the jurors? Is that what happened?
Kind of. What happened first was the judge ordered them to disregard what had happened. So she gave them an order to disregard it. Then,
Was there any inadequacy in the judge's admonishment to the jury to disregard?
yes, and mostly in the voir dire to the jurors. So first, there was, it seems strange to mention it, there was never an objection to the outburst. There was never a motion to strike, which is something that's required, at least in this court, in the State v. Daly case. But the voir dire is the problem, because they weren't really asked anything about the specific incident. They were just, so they had been ordered to comply or to disregard this, and then
You seem to take issue with the fact that that admonishment was made before voir dire of the jurors occurred.
I think the fact
Is that
that
a
it was,
problem?
I feel like you're ordering the jurors, who obviously respect your position as the judge, you're ordering them to disregard this. It seems strange then that you would go back to them and essentially ask them, are you able to follow this order? Well, they have no choice but to say yes. And then the voir dire was mostly, did you hear my order? Can you follow it? Do you think you can still be impartial? Well, that didn't get into the fact that, these people had what they had seen. I mean, the video shows they had seen everything. I mean, they had seen, I was 6 inches from this guy. There was a lot of blood. He required nearly 100 stitches.
What do you think the judge should have asked?
I think the judge should have gone into with each individual juror and should have asked, what did you see? How did that affect you? Do you still think you can be impartial? And then say, we've talked to all of you. We believe you can be impartial, and then disregard this, and this can't factor into your decision.
But the judge did ask if they could be impartial.
The judge did ask if they could be impartial. We just feel it didn't go far enough, and we feel like really any instruction or questioning at that point was pointless.
So automatic mistrial.
I believe so on this. I think had it just been an outburst and anything other than that, but
Was there any kind of break between the judge's admonition that you should disregard what you just saw, and then were they immediately voir dired, or was there a recess of some kind?
I think there was a recess. It was the same day, but I think we may have had a break for lunch or something like that, and then we came back and took them in individually. If I remember right, I think that's what happened, but it was a relatively quick process. The thing is, it would not be unusual for a juror to see an outburst, especially with this defendant. They were expecting it. Everyone has seen people yell before. Nobody had seen anyone slit their throat in front of them before. That's why I think in this case the only remedy was the mistrial. And in fact, when we first went back into chambers, when everyone is clearing the room, we all assumed that he was dead. That was what we thought. It turned out later that it was not. I think he was back. He was at least out of the hospital later that evening. But
Is your view of this event, pardon me, in the applicable law, that there's a continuum when there's an event of this nature, right? So there may be an outburst to be managed, but in your view, this event required an automatic mistrial. And if that is the law, where does that leave the trial judge? Or doesn't it leave the system of the trial at risk for staged mistrials?
well, yes, I believe it should have been an automatic mistrial, but I think that's cured through a more in-depth voir dire of the jurors. I think we just don't have any information.
It was curable. in your view? Is that your position?
This one I don't think is. I agree that it's a spectrum, and I think this is just so far at one end that it would never not end in a mistrial, just because it was so shocking. But I believe normally an outburst, something like that, can be cured. That was one of the things that the Manny case talked about, and about how it depends on the context of the trial. In the Manny case, they said, if this outburst had happened in a tax, some sort of a tax fraud case, it wouldn't be a problem. But in that one, they said, their allegation that this guy is involved in a street gang, so that makes it even worse. And here we're dealing with, a man who has admitted to killing someone and dismembering him. It's hard to argue after they've seen him slit his own throat that he's incapable of violence.
If there's a possibility of automatic mistrials, what protection is there against a defendant perceiving that things aren't going well and staging what he needs to stage to get an automatic mistrial?
I think, metal detectors, but also I think the voir dire. I think the questioning of the court needs to be more in depth.
But I hear you to be arguing that there's at least some incidents that are so egregious that they can't be cured by voir dire. And so what protection is there if there's the possibility of an automatic mistrial? What protection do we have against defendants perceiving things aren't going well and doing what needs to be done to create that situation?
Well, just the protections that we already have. I guess. I don't know specifically. I can't come up with something to tell you we can do, but I would think, following the protocols that we already have in place should do it. This is a pretty unusual event. It's not, every day that a defendant is going to have a weapon on them or something like that. I think the court did everything that it thought it could do to prevent this. We had some indication that something could happen early in this case just on the prior behavior of this guy, but then we, just everything, they hadn't followed any of their rules, and so we're kind of stuck with this. And it just seems like at some point, and this is that point, there's just nothing you can do. The jurors saw all the blood and they saw what happened. I just don't think there's a cure for it.
At the time when the curative procedures were being imposed by the court, did you make any recommendations to the court for deeper voir dire or anything like that?
No. So
Were you allowed to ask any questions?
no, we were not. So the court just handled it on her own, and they only allowed one attorney from each side in the room, and that was basically it.
And were the interviews of the jurors done in chambers?
They were done in chambers. So the judge and one lawyer from each side, and it was essentially
And
three
one juror
questions.
at a time.
One juror at a time. And I don't know if a deeper questioning would have cured this. These jurors were pretty excited to be involved in this case, it seemed at the time. So I don't think any of them wanted to go. It seemed to be getting more exciting as they went on. But that was just something we were kind of stuck with. Just to kind of show the environment we were faced with as defense counsel. At the same time, and this was not listed as an error, we made a motion for a competency evaluation, and I believe the court said, I have not seen anything today that would call his competency into question, so I'm going to overrule that motion. So that's kind of what we were faced with. We have a difficult client, but we are also faced with jurors that really want to be there, and the court obviously didn't want to start this over again. That was, I think, the bigger issue. I think had this been, a normal assault case or something like this, a 3-day jury trial, I think this thing would have been a mistrial every time. But we had all been working on this thing for 2 years. We had all cleared our schedules for a month. We've got one of the most difficult defendants that anyone really has probably had to deal with. And so I'm concerned that that was the bigger issue, that we got to keep going. We have to get this thing done. And so I think that was the error. I think that's the problem.
Is that a bit of an expansion upon your argument you provided in the brief?
It is. But I mean, I think that's just my opinion. I think that was one of the factors that weighed into it. I think that's just one of the things you're dealing with at trial. I mean, I think we've all probably had mistrials for much less than this. I certainly have. So that's what we were kind of stuck with. And then mostly the argument on the motion for new trial was the same thing. It's just we brought in that new evidence of what had happened that led up to him having the razor blade. And so we argued that under irregularity. And then really, we also made the argument for new evidence that couldn't have been discovered and would have been used at trial. Realistically, knowing that it would have only been able to be used in the motion for mistrial. So it would be new evidence only in that context in our motion for the mistrial. So that was the motion. I think that's about my time. Obviously, all of the other arguments are in the brief. I think you've heard most of those before. We believe that Mr. Trail was denied a fair trial, although we understand most people their feelings aren't hurt by him getting the death penalty. These are the most important cases. This is where due process and equal protection are the most important, and we would ask that the case be remanded for new trial. Thank you, Your Honors. Any questions?
Thank you very much. Mr. Smith, good morning to you.
Good morning. May it please the court, I'm James D. Smith, Senior Assistant Attorney General, appearing on behalf of the appellee of the state of Nebraska. Concerning the main issue talked about in the appellant's argument, I think it probably needs to be reinforced that the standard of review is abuse of discretion for denial of a motion for new trial. Frankly, the district court did one of the most impressive jobs I've ever seen of managing a trial and outburst. Should be highly complimented for the way she handled this. She immediately adjourned the proceedings. The defendant was taken out for medical care. Court reconvenes in the afternoon. The judge gives the jury a cautionary instruction, which included they should not consider the defendant's outburst when they consider the issue of the defendant's guilt or innocence. The judge then, on top of that, does individual questioning of the jurors, makes a finding that is supported by the record, and uses her discretion under the circumstances to deny the motion for mistrial. Abuse of discretion is typically known as the court doing something that's untenable. What the district judge did in this case was totally tenable and reflected a very experienced trial judge showing good judgment in managing a trial in which something unforeseen happens, and that's namely the defendant trying to cause his own mistrial, which the law in Nebraska is defendant doesn't get rewarded for bad behavior, and the defendant in this case was not rewarded, certainly should not be rewarded. There was no abuse of discretion here, rather it's simply a district judge who should be complimented for how well she handled and managed what could have been a very difficult trial.
What role does the alleged negligence of the county have on this issue?
None.
Why not?
essentially under State v. Grant, when you try to blame others for your own misconduct, that's a non-starter. And that's what the defendant's trying to do by blaming others for his own misconduct. Under State v. Grant, the blaming others for his own bad behavior is it's not a tort trial at that point where we're suing for negligence or anything like that. It's, did the defendant engage in bad behavior? Yes. Was it willful? Yes. Can the defendant cause his own mistrial? No. Did the judge, under the circumstances, take proper measures to manage the trial? Yes. It's presumed the jury follows the judge's instructions. The judge instructed the jury not to consider the outburst which was proper, inquired of the jurors, made finding that the jurors could remain fair and impartial. There's just, there's nothing there. It's under the appellate standard of review. There just is no abuse of discretion. Unless the court has other questions, frankly, the remaining assignments of error, I think, are covered in my brief, and they reflect that the defendant really doesn't have much to talk about after we had a district judge who really did an excellent job of presiding over this trial.
I do have a question about the death qualifying of the jury during voir dire.
Sure.
And I see in your brief that you're saying this was actually a death qualification anyway, but assuming that it was a death qualification proceeding, does the fact that they waived the jury for the aggravator stage have any impact upon that?
Well, I think it's difficult to argue. Yeah, to me, I've made that argument before. If you waive a jury, how are you able to then complain about the jury voir dire? Because you made an intelligent decision, informed decision, to waive a jury, so how can you complain about the jury voir dire? And they also waived him on cause, so they passed the jury for cause. So that again is another issue. It doesn't go anywhere.
Well, following up on an argument they made in their brief that the death qualification of the jury didn't need to occur because you just, under our system, the jury could just not be informed the death penalty was part of this. And once you remove the aggravator stage out of it, is that a possibility even if you move the aggravator stage out of it to hold a jury in Nebraska, in kind of ignorance of the fact that this is a death penalty case?
No, because I think it is still appropriate under our statute and constitutionally to inquire of jurors whether they're going to remain fair and impartial, because there is a possible penalty of death, even though they're not going to be the ones making that decision. The fact that the defendant could be sentenced to death, it's proper under our statute and constitutionally to inquire as to whether, because of that potential, does that mean you can not be fair and impartial on the thing you have to decide, which is guilt or innocence?
Thank you.
In conclusion, we would ask the judgment be affirmed.
Thank you very much. Do we have any time for rebuttal?
No, Your Honor.
There is no time for rebuttal. Counsel, thank you very much. That concludes arguments. State versus Trail. I'm not sure, Mr. Murray, are you appointed in this matter?
Yes, Your Honor.
Thank you very much for your service. The court will go on to the next case of the day, which is Edwards versus the State of Clark. Mr. Becker, good morning to you.
Good morning, Your Honor.
And Mr. Puck, also good morning to you. Do either counsel have any questions before we begin?
Yes, sir. Good morning.
You may proceed.
Thank you, Your Honor. May it please the court, the undersigned represents Tanya and Jennifer Edwards. Jennifer and Tanya are widows who lost their husbands in a tragic shooting where the boyfriend or ex-boyfriend of their sister shot each of them during the process of attempting to help move their sister out. After the shooting occurred, John Edwards was still alive. He made a call to Douglas County 911. Despite the ability to timely respond. There was delays in responding. Ultimately, Douglas County failed to arrive or render aid to John, even though he had multiple calls to 911. The call was handled by 911, by its own admission, extremely poorly. Ultimately, John died of blood loss by not being attended to. Unfortunately, he was in the basement, even though Douglas County had made entry to the home. Might have been saved, but they didn't bother to go downstairs and check for them because they saw Jason Edwards lying in the doorway and they assumed there was nothing they could do. Ultimately, a suit was brought against Douglas County on behalf of each of the Edwards widows and the estate of John and his brother Jason and their children. Douglas County settled that case.
Counsel, were those settlements funded by an insurance policy? And if so, what is the impact of that under Section 13-1960?
I don't know that either of those, it was not disclosed, the source of those payments for Douglas County. They made an offer to us. The combined offer was $300,000 for Jennifer Edwards, $50,000 for Tanya, plus an assignment of the claims they had made via their third-party complaint against the estate of Mr. Clark, that they labeled in their third-party complaint as claims for contribution and indemnity. When we settled with Douglas County, it went through the process of being approved by the Douglas County Board, but to my recollection, the check came from Douglas County, so I don't have firsthand knowledge as to the source of the payment. We accepted their offer on the terms presented, and so I can't say for certainty how much, if any, came from the insurance company.
Is that issue or the answer to that question important to our consideration of the county sovereign immunity?
I could see that it could be because they assigned any claim they would have to indemnity and contribution, and as we set forth in our complaint, part of what we're saying is they incurred attorney fees and expenses during this litigation process. Now, what I will admit to the court, Douglas County attorneys are the ones who defended that. It wasn't an insurance defense firm that came in, but I don't know background, who was paying their expenses, et cetera.
Thank you.
But the bottom line.
Do we know the date of that settlement? Is that in our record?
The settlement is not in the record because this was determined on a motion to dismiss, and so there was no evidence of the settlement agreement itself.
So the date of the settlement is not in our record?
I don't believe so, Your Honor.
It's alleged in the complaint, but not, no date is alleged. Is that correct?
That's correct, Your Honor, to my recollection.
Does that have any bearing on this issue?
I don't think it has any bearing except on the remote possibility that you're looking at whether or not the settlement was reasonable. It is after the Mosser decision, but before this court's decision in the Julie Edwards case against Douglas County 911. And I think there's enough distinctions in the handling of the 911 call and Douglas County's response. For example, they left Tanya Edwards lingering there, knowing that her husband was dead, didn't tell her, knew she was on the site for 10 hours, made no mention of it, and she found out when her daughters found out about it on the news, who then reported it to her. There are other bases upon which Douglas County could have been liable. But I think that the fundamental issue in this case, and is articulated in my brief and is articulated in the motion to dismiss, the question isn't whether or not Douglas County is immune. The question is whether or not Douglas County had a cognizable claim against Mr. Clark for the attorney fees and expenses they incurred in that defense. They assigned those claims. They assigned to us any claim that that was asserted or could have been asserted against them in their third-party complaint against the estate of Kenneth Clark.
And the language of that complaint is contribution and similar matters, right?
Yes, it says, I think their third-party complaint says contribution and indemnity. But again, in a motion.
Indemnity, right.
Yes,
The
but-
suggestion being that in some manner the county was put out or redirected its resources economically.
Yes, and I think under Restatement Second, torts 914, expenses of litigation, one who the tort of another has been required to act in protection of his interest by bringing or defending an action against a third person is entitled to recover reasonable compensation for loss of time, attorney fees, and other expenditures thereby suffered or incurred in the earlier action. That concept is reiterated in Teethrow versus Wolf, 223, Nebraska 631. But the concept is Douglas County brought this third-party complaint, and the estate didn't move to dismiss it when Douglas County brought it. Douglas County merely assigned and said, okay, we're going to settle with you, we're going to pay you some money, you go pursue our claims against the estate
Such as
of
they
Kenneth Clark.
Pursue the, whatever it was that was assigned, was assigned.
That's right.
Was it assignable? And do we have any case? Can you cite us to any case in Nebraska where the government can assign the rights to recover something to a private party?
It was approved by the Douglas County Board. It's a chosen action. It's a right. I'm not aware of anything that prohibits it, and the Douglas County Board approved this settlement. And it's recognized, as pointed out in our brief, it is recognized that assignment of claims is a valuable consideration that's recognized in a variety of contexts that may be an element of a settlement agreement.
We're not at the point of valuing that or its assignability. Is that correct?
Right. The whole issue here is there a cognizable claim? Is it plausible? It was certainly plausible when Douglas County brought it and they answered. They didn't move to dismiss. We're just merely stepping in their shoes and continuing that claim.
The settlement was after Moser.
Yes, it was.
Okay.
But the issue is whether or not we don't have to affix legal theories. We don't have to. All we have to do is state a plausible, cognizable claim under your Tyrion versus Tyrion case, and the other in Mahum versus Mahomed case that's cited in my brief. The question is, do we state a plausible case? Douglas County incurred defense expenses in defense of a suit brought that arose out of the conduct of Mr. Kenneth Clark. Now, we're saying that they had individual liability for the negligent handling the call, but the bottom.
Let's get off assignability for a moment, and let's talk about the facts of the case. And I don't mean to be disrespectful, but if I may say, the widows. Okay. What is the claim that was brought by the widows?
Against whom?
That's the question.
Okay. In their original stead,
Yeah.
it was negligence against Douglas County relative to the handling of the 911 call
Right.
and the handling at the scene, the cause of emotional distress. Relative to the
Right, so on the
assigned
emotional
claim,
distress, we have a widow on the lawn waiting to hear about the outcome with her husband, right?
yes, that's
Okay.
misled. That she's being
Right.
told,
Right.
he's still alive. Don't worry, don't worry.
Right.
They know
Is
he's
this at the
dead.
point, as we said in Edwards, there's a possibility that things are so attenuated from the behavior of Mr. Clark that this would be a viable claim?
Yes, and that's ultimately one of the things I would have argued, because in the 911 call, it is so abusive to John. The 911 call responder is laughing at him, making fun of him. He's saying he's shot. He's saying, well, go up and go check out what the address is. It was a horrible, horrendous response to the phone call, and even admitted, which would have caused him emotional distress even in his dying moments. But aside from that,
Well, given the jurisprudence in this state, is it your position that those events were so attenuated from Mr. Clark's behavior that they stand up on their own?
I believe so. But that's an alternative basis. I say in my brief that I think it's that we have a cognizable claim still against Douglas County. They settled with us for a reason after Moser. They had Moser. They
had
could have
the
said,
law.
pardon?
They had the law. They had
Yes,
the
and they
Moser
still
law.
settled with us
Okay.
because they recognized there was still some risk.
Does there have to be some type of common liability?
I don't believe so under the indemnification principles. If equity and good conscience and notions of justice that compel you to pay money or incur an expense because of the conduct of another, you have an equitable right of indemnity or subrogation. That's set forth in our brief.
If we've said there needs to be common liability, is there common liability here?
I think there's arguable common liability when you look at the additional facts of how Douglas County handled the response at the scene in the 911 call. But regardless of how
But even in your allegations, don't you say that's because of the potential acts of Mr. Clark?
everything's put in place because of Mr. Clark. True.
What's the theory, if you will, for the claim of subrogation? Is it contractual subrogation, equitable subrogation?
Equitable subrogation.
All right. And then what are the facts that you pled that support a theory of equitable subrogation?
that Douglas County, as a consequence of Mr. Clark's actions, was compelled, I'm just trying to pull my, I think it's a paragraphs 27, 28, 29 in terms of the allegations, but I say in 27, whether it characterizes indemnification, contribution, or subrogation, the estate of Kenneth Clark owes money to Douglas County as a consequence of the fees and expenses it incurred and the reasonable settlement funds expended. Such costs are appropriately the responsibility of Kenneth Clark. At a minimum, Kenneth Clark's negligence, errors, and omission caused Douglas County to suffer loss and incur expenses in the defense of the suit brought by the plaintiff. 29, plaintiff seeks judgment as assignee on all claims which Douglas County could have recovered against the estate of Kenneth Clark, including all claims at law or in equity for subrogation, indemnification, or contribution.
Have we, in Nebraska, does our subrogation case law indicate that a voluntary payment does not give rise to the right of subrogation?
There is verbiage to that effect, but they incur defense costs irrespective and independent.
Did they voluntarily make a payment, or were they required by a judgment to make a payment, and does that matter?
I don't think it matters because they incurred the defense costs. And there can be a distinction between the defense costs they incurred, which are recoverable under the restatement, and the amounts that they voluntarily pay. But then I think you get into the question of whether or not under all the facts it was reasonable for them to make the payment. But the bottom line is, I
beg your pardon, because since Moser, the city's been writing checks in a lot of cases. Is that correct? Do you know?
I can't say that I know, other than I know they paid this after Moser.
Okay.
And we made the same arguments that I'm making here, that you have independent things that you have to be worried about. And the sophisticated attorneys who represent Douglas County in all sorts of tort claims said, yes, we do. And they paid out 6 figures of damages, even though they had Moser in hand. I just think if this was Douglas County up here on a motion to dismiss, I don't think there'd be any question that Douglas County would say, regardless of whatever label you put on it, we have a cognizable, plausible claim against Mr. Clark because we incurred expenses and money defending the claim.
They alleged that in good faith.
Yes.
They alleged contribution in the third-party complaint.
And then they assigned those
Right,
rights to us. We're just stepping into their shoes.
Okay, so they wrote up something they thought was true and told the court, we verily believe there's something here.
Yes. And they answered. They didn't move to dismiss. I don't think if this would have ever been dismissed if I was a Douglas County attorney with a Douglas County hat on saying, we want our money back because of this bad guy and his conduct because we reasonably incurred defense costs. It shouldn't make a difference, the fact that it's the widows bringing this claim and the fact that this court decided Moser and then the Julie Edwards case. You should look at it as if we were Douglas County, and if you looked at it as we were Douglas County, this is a plausible claim. Is it plausible that Douglas County had the right to go seek money from Mr. Clark for the expenses it incurred in defending itself from the actions that Mr. Clark instituted by virtue of his shooting John and Jason Edwards? If the answer to that is yes, which I think it should be, then we have a cognizable, plausible claim, and this case should proceed forward beyond the pleading stage.
Your argument assumes assignability, is that correct?
Yes, it does.
Thank you.
Thank you very much. Mr. Puck, good morning to you.
Good morning, Justices, Chief Justice. I guess I would like to start with, since I think this court is very familiar with the facts of the underlying cases, including Julie Edwards in 2021 that was before you. This is a third-party practice claim. So we have a claim by the Edwards, 2 cases, against Douglas County, alleging their negligence based upon the violation of an untimely response. And I will say, I think the whole situation is egregious. But you heard Edwards, you decided on Edwards, and I understand the dissenting opinion, but you decided on Edwards in reference to whether or not Douglas County has liability under the Tort Claims Act based upon the actions of Mr. Clark. And you decided they did not. So let's start with third-party practice. We have Edwards suing Douglas County, of course, suing Mr. Clark because he's the murderer. If they're going to be held liable, of course, then they believe Douglas or Mr. Clark should pay. Nobody disputes that. What is disputed is that under the third-party practice, all defenses that are viable based on an assignment that Douglas County would have given to the Edwards are available to the third-party defendant. That means that the Edwards have to prove that Douglas County was liable before there is any contribution, indemnity, subrogation.
And so in a motion to dismiss, your position is contribution really never existed?
Based on...
Although you pled it, verily pleaded it on your third-party complaint. And answered.
Correct, based upon, of course, that there's affirmative defense is pled that there's no cause of action.
Right.
And so if we skip over the third-party practice analysis and just go right to contribution, nobody's going to deny that if Douglas County is liable, Mr. Clark owes it. He murdered him. There's no question of that. Nobody disagrees with that. The question becomes, in this case, with the assignment of Douglas County, they take subject to any defenses.
But we have a number of allegations in the initial complaints by, I say respectfully, the widows, right?
Yes.
Right. And so their position, at least with the commencement of that suit, is, and after Moser, right, this thing of the widow sitting on the lawn waiting to hear about the outcome of her husband did not arise from Clark's actions.
But did it, is the question.
Well, her complaint would take the position that it did not after Moser, right?
I guess...
In order to evade immunity.
Can I break that down? So I don't believe the complaint actually says what you just stated, but it does state that she was on the lawn waiting to hear and they didn't tell her appropriately.
Right.
That is alleged.
Well, if she's on the lawn and she's waiting to hear about the outcome of the husband and I don't know, there's an ambulance on the scene and they run her over. Now that's just common knowledge. It wouldn't be under one of those little categories about intentional torts.
But it's derivative of the actual
So that
event.
would also, she's sitting on the lawn and an ambulance accidentally runs over her, right? That arose from Clark's behavior. Everybody's there because of what Clark did.
I would tell you that I agree that that becomes untenable to the actual act of the assault and battery based upon the analysis of the cases in Moser and
But we said in
Edwards.
Edwards, at some point, the intentional action of a non-state actor, for whatever that's worth, that it's attenuated at some point. That's not attenuated?
The ambulance example, I would say, is probably not attenuated to the act of assault and battery, just because they're at the location. The issue of why she was there, the purpose of the
Right.
police being there, all is inextricably tied to the murder by Mr.
Well,
Clark.
the law in this state is inextricably linked, but the question is, did it arise under the intentional tort?
I believe yes.
Okay, so
Yeah.
the ambulance runs her over, that arose from the Clark's behavior too.
Again, I would say you're getting into a factual basis that I would agree with you, Justice, that may be an analysis that gets past that, not attenuated to the actual assault and battery.
Right, and there could be liability by the county, and if there were, regardless of who writes the check, they spend time and redirect their resources, even if they're salary people.
I'm not sure what you're saying there, and back to the ambulance example, again, the ambulance would be liable
No,
necessarily.
I'm back to whether or not there's based on allegations, but no more, are there plausible contributions? You all pled it, so you must have thought, maybe there is.
Plausible contributions, you mean for defense costs and so forth
The third-party
associated with
complaint.
the settlement?
The third-party complaint
Okay,
alleges contribution,
contribution based
or
upon,
indemnification, or both, no, it says both, actually.
it does say contribution and
Yeah,
indemnification.
they both say both, right.
But it does state that to the extent that they are held liable for the actions that are alleged in the initial complaint by the Edwards against Douglas
Right.
County, we state Douglas, or Mr.
Right.
Clark needs to pay
Right,
that because
right.
he's.
So the question is, regardless of who writes the check and whose pennies they are, the question becomes, was there ever really a case that the widows had?
But my position would be no.
Okay.
Based on Moser, number one, and
Did the county
why,
have liability?
no,
Is that necessary?
yes.
Counsel, I want to ask about whose pennies they are. Did this settlement, was this settlement funded by insurance proceeds? And if so, what does the Political Subdivision Tort Claims Act say about sovereign immunity in the event there is liability insurance coverage?
So to answer the first question on insurance, I would agree with counsel that none of us were privy to who paid or where the check came from. I will advise that and there's nothing in the record that indicates in normal subrogation cases from insurance payments that you get a notice of lien or notice of subrogation. Easy examples are automobile cases, correct? Medical insurance pays. I would also state that, unfortunately, there's nothing in the record that would reflect that, so I can't answer
So is
that
it
either.
too
If it is-
early to answer that question?
No.
If it is
Doesn't matter.
jurisdictional, do we have to know the answer to it?
If it's jurisdictional, possibly, yes, but if there are not any allegations set forth in the complaint, third-party complaint, or any issues related to this before the court, then it is irrelevant. Nobody has alleged that a party that should not have had to pay, but did pay insurance company, for damages alleged by Douglas County, voluntarily paid, by the way, as of course we know in settlement, that they are entitled to the money back. Maybe that's an issue you believe should be discussed, but it's not in the record. And it could have been in the record should someone had made a claim for subrogation or lien or notice of that. In this case, that's not here.
We don't know the facts.
We don't have any alleged facts to that either, but that's true.
We don't know the
Correct.
facts. Have we not said in Crawford and Ryan, not everything's jurisdictional? We should be very careful when we use that.
I don't disagree with that, Your Honor, and I would tell you, if you look at the face of the pleadings, which is the de novo review for the motion to dismiss, there is nothing alleged to that extent, that money is to be due or paid back so it becomes a jurisdictional issue. I do not believe it does. Because if it goes to the issue of liability, you can go through contribution, you go through indemnification, both of those. One is a common liability, and an indemnity, if it's not by contract, clearly there has to be common liability again. And there is no liability against Douglas County associated with the Moser and Julie Edwards cases to the extent that those two would apply. You go to subrogation, it's a voluntary payment. They didn't have to make the payment, it was settlement. I wasn't in the minds of Douglas County attorneys to the extent that I would know why they settled, why they didn't file a motion to dismiss when it was
Does this
first.
record show that since Moser, the county has settled a number of intentional tort cases, including school cases and others?
It's a good question, but the record does not show that in this case.
What is your position, counsel, on the assignability of any claim for indemnity contribution or subrogation that the county may have had?
That is a very good question that I don't have an answer to. My position on that is...
Do you agree that we need to answer it in connection with this case?
I do not, because even
Why
if
not?
it is assignable, you go to the analysis of third-party practice again, and you go...
What if it's not assignable?
Oh, what if it's not assignable?
Yes.
If it's not assignable, then why we wouldn't be here to begin with, and why would their analysis need to be done? Because if it's not assignable, it fails on its face. Is how I would answer that, I guess. I don't know of any cases that prevent it, like counsel indicated, of assignability. There's nothing in the record, or I guess in the briefing, that identifies whether it's assignable or not. But you get back to the issue is where we are today on the pleadings, which on a motion to dismiss, on its face, paragraph 35, but for Mr. Clark's actions, none of the damages I'm asking for would have been incurred.
Right.
That
This is a motion to dismiss, so we would have to say there's no plausible way the county could have been responsible, and so that that third-party complaint was just DOA.
That's what I would agree. And I don't know why Douglas County didn't at the beginning. I'm involved in this case from the sense of a murderer. I have no defense other than if Douglas County's liable, I'm liable. I get that. That's clear.
Right.
I mean,
But
this
we
is a
have
horrendous,
We have a
heinous...
pleading filed presumably with intelligence and verification.
Yes.
Thank you.
Yeah. I think my time's done. If there are not any further questions, I would ask, if you look at the analysis based on the facts and the pleadings that are before this court, it is clear, based upon the history in Moser, but particularly in Julie Edwards, which is the same factual statements, that if Douglas County has no liability, there is no contribution, indemnity, subrogation. I ask that it be affirmed. Thank you, Your Honor.
Thank you.
Thank you very much. Do we have any time for rebuttal?
No, Your Honor.
There is no time for rebuttal. Counsel, thank you for your arguments in Edwards versus the State of Clark, and you are excused. The court will go on to the next case of the day, which is in re interest of, I'm going to pronounce this, Abasai P. Ms. Kearns, good morning to you. And Mr. McMahon, you are also here today. Do either counsel have any questions before we begin?
Justice, I do have one question. I have a senior certified law student with me. Is she able to sit at counsel table and confer in between arguments?
She certainly is.
Thank you.
And you may proceed.
Thank you. Mr. Chief Justice, may it please the court, my name is Melinda Kearns. I'm an assistant public defender appearing on behalf of Douglas County on behalf of Abasai P. I would like to reserve 2 minutes for rebuttal. As this court is aware, this case is an appeal of an adjudication of a truancy case in juvenile court. Before I get into the substantive portion of my argument, I would like to address some technicalities. As you are aware, in my brief, I noticed that the juvenile court committed plain error in finding under the wrong subsection of 43-247. The court found under sub 1 as opposed to 3B. As the court is aware, sub 1 is a misdemeanor. The court also used an unclear burden of proof, finding under sub 1 on proof beyond a reasonable doubt based on an entered and accepted plea, and on proof beyond a reasonable doubt based on the preponderance of the evidence. We feel this creates an unclear record for the court.
And you raised that as plain error because you did not ask the court to alter or amend its adjudication order based on those very things you've just described to us, right?
Correct.
Thank you.
In addition, Abasai is asking that this court reverse the order of the juvenile court due to violations of both procedural and substantive due process. I'd like to start with first procedural due process. We believe that the juvenile court erred when it adjudicated Abasai without him being present and without him being informed of his rights pursuant to Nebraska Revised Statute 43-279.
Did you present that issue to the trial court?
I did not, no.
Did you object on that basis to proceeding with the adjudication hearing?
No, I did not. I
So would we have to reach that on plain error as well?
I believe the court could also apply, not just under plain error, but that it violated the statute under 43-279.
But did you raise that issue to the trial court?
No, I did not.
Thank you.
Was there any proof of notice was provided to the juvenile to be there on that day?
No, there was nothing in the record that notice was provided to the juvenile to be there.
So there's nothing that would show that he waived that appearance in any manner?
No.
Thank you.
It is clear under 43-279 that the court must inform the parties, the juvenile and their parent, guardian, or custodian of their rights. In this case, the court never informed my client or his parents of the rights prior to trial. As stated in my brief, the Court of Appeals found in right interest of Tory B that it is axiomatic that a juvenile may not waive his or her rights to be advised of his or her rights. And this court also found recently in re Victor L that the court must give effect to all parts of a statute and no word, clause, or sentence should be dismissed as superfluous or without meaning. It is clear under the statute that the court must advise of the rights.
Were you present at these hearings, or did Abasai have a lawyer present at these hearings?
I am his lawyer, yes, I was present.
What impact does the parties refer to it as a written denial? I think of it sort of as a written waiver of arraignment. That may be imprecise. What impact does that written denial or written waiver of arraignment have on our analysis here?
So the written denial was modeled after the criminal court waiver of appearance, plea of not guilty, where generally the lawyer just advised briefly of the rights.
Did the court accept that, so order
Yes.
it?
The court did accept it. It's contained on page 8 of this transcript, and then the court made reference to it and the order.
When that's typically done, and then the case is set for adjudication, does the judge re-advise them of their rights?
Absolutely. Every court, before this, after this,
Assuming they appear at the adjudication.
yes. At the following hearing, adjudication, or trial, the court does re-advise of all rights and possible consequences when there was a written denial done prior. And so this written denial is a local rule. There is no statutory authority for it. It's been around. I've been practicing for over 20 years. It's been around since then, but it was definitely used at the height of COVID by all 6 courtrooms, kind of as a way to not bring lots of people in at once, because a lot of times these were done with multiple kids and parents all in front of the court at the same time, hearing the same rights and consequences. So this was just done to basically acknowledge that they are aware that these charges have occurred, but their attorney has advised of their rights, but in no way functions as a waiver, nor does it state that it's a waiver of the court actually having to give the advisements. Regarding the next part of my brief, we also believe that besides procedurally violating FSA's due process, this was also a substantive violation of his due process. In these proceedings, normally when a juvenile does not appear in court for any proceeding that is substantive, the court will either continue the matter one more time, usually, or issue a capias for the location of the child to be found. In this case, neither was done.
Was there an objection based on substantive due process raised at the time the court proceeded with the adjudication hearing or denied the motion to continue?
I don't believe I made it exactly in those words, but I did make reference to the fact that proceeding would lend less credibility to the proceedings for both my client and his parent for buying in on the rehabilitation process, which falls under due process.
I want to go back just a little bit, and I apologize because this was a part of your opening remarks. Is this a correct statement of the order that the judge said proof beyond a reasonable doubt based on preponderance of the evidence?
Yes.
Is that
Sorry, is that correct, or
is that what is that what was said?
I don't believe there was an actual finding on the record. That came later in the order. But yes, that is what the order says.
The order says that. Did I read that right?
Yes.
Okay, what's that mean?
That's our point, that's an intelligible.
What did the judge say on the record?
I'm sorry, I would have to refer to the transcript. I think it was something along the lines of finding the petition true.
But did the petition allege the right subsection?
The petition did, yes, but the order did not find under the correct.
Did the court rule from the bench that the allegations contained in the petition are true, and that was the judge's finding, and then the matter should be set for disposition? Was that the oral pronouncement at the time of the hearing?
I found it right here. It says that the court hereby finds that the allegations contained in the petition are true, and this matter shall be set for disposition. So the next hearing. That's all that it said.
Is that enough? Let's assume there isn't a written order. Is that enough?
I don't believe so under 43-279. Under 43-279-2, if I could continue, that the court shall make a finding and adjudication to be entered on the record of the court and describe that the juvenile is a person described under subdivision 1, 2, 3B, or 4 of 43-247 based on proof beyond a reasonable doubt.
And the infraction or the event, I should say, perhaps, was truancy under 43-247-3B?
Correct.
That's how it was pleaded?
Correct.
Okay.
Yes. So if I could just summarize regarding the due process, the court has been clear throughout statute or case law, and the statutes are clear that the youth are in these proceedings that are akin to criminal proceedings, that due process must be followed, and the legislature has been clear that fair hearings and all legal rights must be recognized and enforced. this court found in Victor L. that in a truancy case, a youth must be competent. Therefore, it stands to reason that under fundamental fairness, the youth also must be present. The youth was not allowed to be informed of his rights or to exercise any of his rights under 43-279.
If you were successful before this court, what would be the remedy? What would you have us do?
Well, and that's an interesting question because of his age, correct? So we're asking the court to reverse the juvenile court's order, but also to dismiss the proceedings given the fact that my client is age 18 and there is no longer jurisdiction or ability of the state to require him to attend school.
Well, and then conversely, if you were not successful, what would be the impact of our order?
That's an interesting question. I'm sorry, I see my time's out. May I answer?
You may answer.
Thank you. So
We have a certain order here.
I understand. That's an interesting question, because then if it reverts to the juvenile court, then the question, does the court even have jurisdiction to continue to proceed with the client? Under Kevin K., there is some opening that the court would still have jurisdiction. However, my client then is left with collateral consequences of having a truancy without having any sort of basis to attend school, being that he's age 18.
Thank you.
Thank you very much. Mr. McMahon, good morning to you.
Good morning, Chief Justice. Your Honors, may it please the court, Ms. Kearns. My name is Christopher McMahon. I'm a Douglas County Deputy Attorney and I represent the state. Justice Stacy asked Ms. Kearns what impact a written denial has on our analysis, and that question cuts to the heart of the issue, is what impact does that have? A written denial, it's a procedural document. I have a copy of that here today. I don't believe that this court has ever considered what impact that might have. Now, in Stoneland Livestock versus HBE, this court considered a entry of appearance and found that it was not enough to subject.
We recently wrote about this, did we not, in the criminal context, because whether or not the written waiver, or the written not guilty, when it's accepted, could impact counting days for speedy trial in the criminal context.
Very interesting. Now, if that were to be applied to the juvenile context, does that mean that the juvenile has submitted themselves to the jurisdiction of the court? Further, the document itself, which I have here, advises that the juvenile has been told of their rights, that they have been properly served, and that they do submit to the jurisdiction.
Do any of the juvenile court statutes contemplate the use of such a document?
It is not contained in the statute, Your Honor.
Aren't juvenile courts purely statutory?
They are, Your Honor, and that raises an interesting question, is how does this document fit within the construct of the juvenile courts? Now the state and the courts themselves allow this document to be entered.
Maybe it doesn't fit.
That the state...
Assume we were to say it's a nullity. Assume we were to say that. What does that do?
Your Honor, that would have a fundamental impact on juvenile courts. Currently, arraignments are often...
Juvenile courts or just the Douglas County Juvenile Court?
You're right, Your Honor. I'm speaking in regards to the Douglas County. I'm not aware of the procedure for Sarpy or Lancaster.
This is the custom. I beg your pardon. It's a custom in Douglas County, evidently.
They are used very often, Your Honor. And to answer your question, when they are used, the juvenile does not appear for the arraignment. Service is not necessarily perfected by a sheriff. Often service is waived.
So if the Lancaster County Separate Juvenile Court and the Sarpy County Separate Juvenile Court have local rules that address written denials, assume that's true, does Douglas County have a local rule that addresses written denials? Or has it just been kind of the common practice?
It has been the common practice of all 6 of the Douglas County juvenile courtrooms, Your Honor.
Thank you.
So to answer your question, Your Honor, it would have a tremendous impact if this court deems that it is not sufficient to merit the words that are contained within. Now, Your Honors, Ms. Kern's brief assigned 3 errors to the juvenile court.
Before you move on to that, I'd like to talk about that document real quick. Does that document, is it signed by the juvenile or the juvenile's parents?
No, Your Honor. I have it here. It's signed by the attorney, and in it, it states that notice, service, and jurisdiction are proper, that a copy of the petition and summons were duly served on the child and his or her legal guardian according to law, and then it advises of the rights and it delineates each of the rights.
And do you agree with the appellant's attorney that there is actually nothing in the record that shows that notice was given of this actual adjudication hearing date to the juvenile or his parents?
Aside from this document, Your Honor.
But there's no date on that document. I mean, there's no date provided when they have to appear for court?
That's correct, Your Honor. It simply has, it's kind of a form document, which I believe is used for all the different actions that come before the juvenile court. So it doesn't have anything to break out specifics. It just says that a copy of the petition and summons were duly served, and that, let's see.
But would you agree with me that if one does not have the notice of the date they're supposed to appear, they cannot waive that appearance? That's nothing that's within their realm of possibilities.
I would agree with that, Your Honor, but I would also say that one of the responsibilities for defense counsel when they fill out this document, and basically they're alleging under oath when they fill out this document that they have spoken and given the rights to the defendant, that part of that advisory would be a notice of when the trial date would be or the next appearance in court.
But the adverse effects of their assurance shouldn't be held against an uninformed client, should it?
No, they should not, Your Honor. That's
Counsel,
very correct.
Does our Bill of Exceptions contain, does our Bill of Exceptions tell us that the judge ordered defense counsel to let her clients and the child's parents know of each court hearing that was set?
I don't believe this particular Bill of Exception specifies that. The state's position is that part of the job of the defense attorney is to notify their client of the court hearings.
So does the transcript contain orders that direct counsel to let her client and her client's parents know of court proceedings?
No, it does not, Your Honor.
Thank you.
Your Honor, Ms. Kearns has alleged that fundamental tenets of due process were violated here, and certainly it is a case of first impression. However, I would point the court to In Re Interest of Brian B. from 2004, that due process is flexible. It calls for protections as the situation demands. The court must weigh the interests of the parents and the state. In this case, it's a truancy, Your Honor. The state has an interest in seeing that all juveniles attend educational programming. The court in re interest of, excuse me, in re interest of AMH, juvenile proceedings are civil in nature, not criminal. They emphasize rehabilitation, not punishment. The juvenile court serves as parens patriae. The purpose of the juvenile court is to care and to guide. Your Honor, nobody in that courtroom was there to punish this juvenile. They were seeking to give the juvenile an education, to make sure they're attending educational programming. The state has an interest in seeing that all juveniles attend educational programming.
So what impact does the current age of the juvenile have on that?
It does have an impact, and in the state supplemental brief, it discussed that, Your Honor. The state has lost all jurisdiction in this matter. If it were to be referred back to the juvenile court, once a juvenile reaches the age of 18, the truancy statute has no longer any effect in this case.
So is this all moot?
Well, Your Honor, it's the state's position that the allegation 1 is moot, Allegations 2 and 3 are intertwined and deal with fundamental issues of due process. If this court deems it necessary to provide future information for the purposes of stare decisis, the state would welcome that. And I believe it was defense's position as well in the supplemental brief that we would welcome a ruling from this court just to provide some, I guess, guidelines, if you will, as far as some procedural safeguards for the future for the separate juvenile court of Douglas County.
Is
However,
the first assignment of error moot if there are collateral consequences from a statement on the record that the child's been adjudicated under 43-247-1?
That's a very interesting question, Your Honor. Defense's position is that this court could overturn that and in effect seal those records. I don't have a good answer for that, Your Honor. I would state that on the record, the judge did say that, which I believe Ms. Kearns went into, that the allegations were found to be true. I would say that the state alleged it under the proper statute. Now, that burden of proof, true, doesn't specify beyond a reasonable doubt, which would have been the appropriate verbiage. But it's the state's position that the allegations found in the petition were found to be true, and that is sufficient.
When you mentioned sealing the record, what would be how would that work?
I don't know that that's ever been done, Your Honor. In our
It's not your position that this is under the Criminal History Record Act?
No, Your Honor. Again, juvenile court proceedings are civil in nature, not criminal. I don't know that there is any outcome for this court to determine under the assignment of error number 1. The state's position is that it is moot. Again, assignment of errors 2 and 3, we would welcome this court's opinion on that. Thank you.
Thank you very much. Do we have any time for rebuttal?
No, Your Honor.
There is no time for rebuttal. That concludes arguments in re interest of Abasai P. Counsel, thank you very much. You are excused in the court. We'll go on to the next case of the day, which is Christensen versus Broken Bow Diaz, which I believe is public schools. And Justice Freidenberg is recused from this matter. So the court will be joined by District Court Judge Stratton. Counsel, you may be seated. And Judge Stratman, welcome to the court.
Thank you very much.
Thank you for joining us. Mr. Duncan, good morning to you. Are you splitting your time with Mr. Harbaugh?
No, I will be using it all.
Okay.
Maybe.
Very good. And also we have Mr. Krejci and Mr. Riley, is that correct? And you are splitting your time?
Yes, sir.
I knew somebody.
Master Riley on behalf of Broken Bow Public Schools.
Okay.
I think I have a 10-minute portion.
It was my intent that Mr. Riley would use his full 10 minutes first, and then I would have 2 minutes after that.
Okay. And you also have 12 minutes?
Yes, that's my understanding. Yes.
I think we've got it straight. Do any counsel have any other questions?
No, Your Honor.
Very good. Then, Mr. Duncan, you may proceed.
Thank you. May it please the court, James Duncan on behalf of the plaintiff appellants Michael and Kathy Christensen, both personally and as next friends and co-guardian and conservators of their son, Chad Christensen. This is a political subdivisions torts claims act brought by the Christensens against Broken Bow High School for injuries that Chad Christensen received as a result of a motor vehicle accident that occurred on June 1st of 2012 in Custer County. We are requesting that the court find that Nebraska Revised Statute 60-6273, which is commonly known as the Nebraska seatbelt defense, does not apply in this case. We are also requesting that the court find that Nebraska Revised Statute 60-6267 also is not as narrowly construed as the district court found. Because this raises a question of statutory interpretation, it's a question of law, and we believe that the court's standard of review is to conduct an independent analysis and reach a conclusion independent of the findings of the district court. Because the status of this case is post-motion for directed verdict, we would also suggest that all controverted facts are to be construed in favor of the plaintiff appellants. On June 1st of 2012, Chad Christensen was a minor. He was 17 years old, and he was between his junior and senior years in high school. He was also a member of the varsity boys basketball team for Broken Bow High School. And on that day, Chad and 7 of his teammates were on a return trip from a Kearney Catholic High School boys team camp. And as they were traveling home in a Ford 10-passenger van owned by Broken Bow Public Schools and used for purposes of an activities van that was driven by assistant basketball coach Zane Harvey, who was also a teacher for Broken Bow High School. And sitting in the front seat, also accompanying the team, was the head basketball coach Anthony Bloom, who was also a teacher for Broken Bow High School. Chad Christensen there was 3 bench seats in this van, other than the front seats. Chad was seated in the middle seat, and he was seated in the center of that seat. Neither Chad nor any of the other students in the van were wearing the available seat belts that were in the van. As they were returning home, and they had just passed through Ansley, Nebraska, a Chevy half-ton pickup driven by Albert Scherbeck crossed the center line and collided head-on with the van, squarely in the lane of travel of the van. Neither Chad nor any of the other students were using their seat belts at the time of the collision. Both Coach Harvey and Coach Bloom were killed, and so was Mr. Scherbeck. Chad's most significant injury as a result of this accident was a severe traumatic brain injury. Broken Bow Public Schools has maintained throughout this litigation that the school is not liable for the coaches failing to ensure that Chad was using a seatbelt, under the theory that the Nebraska seatbelt defense in 6273 applies to make evidence of the non-use of a seatbelt inadmissible for purposes of proving liability or proximate cause, and that based on that, the plaintiffs are not able to prove their case.
What have we said about, are you calling it 273?
Yes, the seatbelt defense.
Right, the non-use, right, is
Correct.
not admissible regarding liability or proximate cause, but is admissible on mitigation of damages.
Correct.
What have we said in the cases that means?
This issue has never been addressed. We believe that this is a case of first impression as it applies to minors.
As it applies to minors?
Yes,
But
to-
have we not said was it Werner, that it only applies to mitigation?
I believe so, when it
And
applies
elsewhere.
to a driver. I think that there's some analogies to be made of how does it apply when it's another driver that has not caused this accident. If it was Coach Harvey in this instance, of whether or not, if he was unbuckled, whether or not Mr. Scherbeck could have made a claim for use of the seatbelt defense against Mr. Harvey if he was not wearing that seatbelt. So yes, we've applied it as to drivers. We do not find any Nebraska case, any Nebraska statutes, and actually don't even find anything in other states with similar statutes that have applied a seatbelt defense to an injured, unbelted minor non-front seat
So
passenger.
you think that makes it different than the cases where we've said it only applies to mitigation of damages?
I believe that that supports the
Then
theory.
how do you integrate, if I may, 269, which says the non-use shall not constitute prima facie evidence of negligence? That's not restricted to drivers or oncoming cars and so forth. That's in 6,269. I'm trying to read these all together.
Yes, and that is exactly, I think our main point is that the statutory scheme, which is titled Occupant Protection Systems, which is 9 statutes from 60-6265 through 60-273. There's 9 separate statutes. They break down into 3 parts. And so what you're referring to, Your Honor, with 269 is part of Part 2 that we believe. And it only refers to a driver failing to ensure that a minor passenger is not using a seatbelt. And so that is a separate provision from 6273, the seatbelt defense, which we believe only applies to persons who are referred to in 60-6270, which places the burden upon the driver not to operate a motor vehicle unless the driver and all front seat passengers are buckled. But that provision wouldn't necessarily apply to a minor because 6267 already requires the driver to have a minor front seat passenger buckled. So 626...
It kind of drops off, though. It just says ensure it's done from 8 to 18.
Yes.
Figure out the legal significance of it. Well, that's why we're here.
That's exactly right. That's exactly right. And the reason for being here, we believe, is very important. It's not just that it applies, whether it applies to Chad Christensen, it applies to every minor passenger that's not seated in the front seat of a vehicle in the state of Nebraska. And if it applies the way that Broken Bow Schools proposes and the way that the district court has found, we find it hard to envision how a minor child that is injured when they are a backseat passenger, that a driver has not ensured that they're using a seatbelt. We find it hard to envision how a child would ever have any recourse against the driver that's failed to protect them.
Hasn't the legislature said they don't have any recourse?
We don't believe so, no. What we believe is that the language in 60-6269, where it states that it shall not be prima facie evidence, is not barring any of that. And certainly we disagree with the district court's finding that 6273, the seatbelt defense, applies to barring plaintiff's evidence. We submit that it only applies to barring defense evidence for certain purposes. And so when the legislature provides in 6269 that it shall not constitute prima facie evidence, what it's really saying is the violation of the statute alone does not prove the negligence, which is common of what we have with most of our other statutes in the state of Nebraska, which is if I run a stop sign, it doesn't mean that I'm automatically negligent. You have to prove that that's a breach if I run a stop sign. But you also have to prove that it was a proximate cause of some injury to a plaintiff and that those injuries resulted in some type of damage. And so those are the elements that still have to be proven of the negligence.
So
and
we have some statutory ambiguity here. Can we look at statutory history, legislative history?
The legislative history, and I won't represent that we've read every single word, but we weren't able to find a lot of guidance in the current scheme of what the intent of this is, because when it was first introduced and then through all the debate, it became something else. Because what we can find is in 1984, it was originally going to be evidence of seatbelt use is inadmissible in any civil case, period. Many states have maintained that type of a language, but through the debate process in the legislature, and we haven't been able to find all those, what happened. It's kind of the making sausage thing of what you get in the end and you don't know.
So what you're telling us is we don't know.
We don't know.
What the legislature
For some reason, the legislature, from when it was first
we assume they knew.
Well, we have to assume that. That's the way that the interpretation reads. But under State versus Alvarenga, the approach that this court has taken is that the intent is to be deduced from the whole of the scheme, which is 265 through 273, and not pull out a particular statute and read that in isolation. And that's what we suggest that both the school has suggested to the district court and what the district court has done is specifically focus on 6273 and make it apply to everything. And so what we suggest is that 6269 applies to minors. 6273, the reason we believe that our explanation applies is because until the enactment of 6273, mitigation was purely an after-the-fact defense. It only becomes a defense in seatbelt issues because of this statute. And it makes sense to say that a defendant cannot present evidence of non-use to disprove liability or proximate cause that his actions have resulted in, because it only comes into play after the driver has been determined to be negligent. So it makes sense of what it doesn't say is it doesn't prevent evidence of duty or damages, which is where the mitigation comes from. If I'm the negligent driver, I've been found negligent, I can address duty. My victim has a duty to wear their seatbelt under 6267 or 6270, not under 6267, because a child does not have a duty to wear a seatbelt. The duty is on the driver. So the child can't breach that duty. That's why 6273 would never apply to a child to prevent that evidence. And
Unless the child is the driver.
Then it does. Then that's my argument. A non-driving, non-front seat minor who is unbelted has a cause of action because there's no duty on that child to be wearing a seatbelt.
Do we have to read a lot into the statute to get there?
I don't believe so. What I finally, when it came to me, and not because I finally was able to make it up, when I took a copy of 6265 and 6266, we define occupational or occupant protection, and we require it be installed. That's the first two. Then if you read 6267, 68, and 69 together, 69 refers to 67, and 68, the penalty provision, it applies to 67. There's a separate penalty provision for 6272, referring back to 6270. If they were to be all together, there'd be no reason for two penalty provisions within the statute. And so then if you read 6270, 71, 72, and 73, those all flow together because they all use the word wear, W-E-A-R. In 6267 and 6269, they use the word use, U-S-E, which we believe is also a clue from the legislature. There's using within 6267 requiring the use with children, and 6270 where you're required to wear. That's the duty on the driver or possibly a front seat passenger that's not a minor. If there are any other questions, I believe I've used my time.
Thank you very much.
Thank you.
Mr. Riley, good morning to you.
Good morning, Chief Justice. And before I begin, I notice I have 12 minutes up on this counter. I'm certainly going to leave my 2 minutes and just use my 10.
That's up to you.
Well, I don't have the 12 minutes, and I don't want to deprive counsel here. Good morning, Your Honors. May it please the court, counsel. My name is Matthew Riley. I am the attorney for Broken Bow Public Schools, which is the defendant and appellee in this case. As Mr. Duncan alluded to, we are up on this court, or before this court, on a directed verdict. This is actually the second directed verdict that the district court granted in favor of the Broken Bow Public Schools. This verdict, this directed verdict in favor of the schools, is the correct result. It is the result that the school district has been requesting, I think, since 2014 when this case first was brought. The court correctly applied the plain, unambiguous language of Nebraska's seatbelt laws to the undisputed material facts in this case and correctly found that the lone evidence of negligence that the plaintiffs have attempted to offer here is not sufficient to prove a cause of action under the state law, and it's not admissible to prove either liability or proximate cause under the state law. At the conclusion of my argument, I will request that this court affirm the lower court's grant of a directed verdict in favor of the school district and hold that the directed verdict was proper under the law. This accident, as Mr. Duncan alluded to, occurred on June 1st, 2012. Mr. Christensen was one of 7 passengers. Mr. Christensen himself, a 17-year-old licensed driver aware of the rules of the road, was an unbelted passenger in the back of the van. There are 3 material facts that I see as kind of the dispositive facts of this case. The first is that when this accident occurred, Mr. Scherbeck crossed the center line directly head on with the school van. The second fact is that as the plaintiffs put on, and their very first witness in this case, Mr. Harvey, the operator of that van, had absolutely no way of avoiding the collision, had no contributory cause whatsoever to the actual occurrence of the collision. And the third fact is that Mr. Christensen was unbelted. In fact, the plaintiff's only evidence, as they admitted at the close of the evidence in an argument on the directed verdict, their only evidence of negligence is that Mr. Christensen was unbelted. This case presents a very basic matter, calls on one of the most fundamental concepts we have as statutory construction, is to simply interpret the rules of the statute altogether, not to include additional words. As you, Justice Papik, alluded to, a lot of these words have to do a lot of work, and we have to add a lot of words to the statute to have it read the way plaintiffs would have this court rule. There are 3 statutes that apply here. I want to avoid the tripping up with all the different numbers of 60 dash and all that, so I have 3 different names for them, I suppose. We have the first statute, which is 60-6,267. I'll refer to that as the duty. That provides that a driver has the duty to ensure that all occupants under the age of 18 are properly belted, are using what the statute refers to as an occupant protection system. The second statute that we concern ourselves with here is the enforcement statute. The enforcement statute is 2 sections later in 60-6,269. That statute provides that a violation of the duty statute, quote, shall not constitute prima facie evidence of negligence. Now, counsel alluded to or suggested that that doesn't rule out using it to prove or using it as evidence of causation or using it as evidence of damage or what have you. But this is clear as day, and it says prima facie evidence of negligence, proximate cause, duty, breach, all of those are subsumed within the definition of negligence. And prima facie evidence under the Black's Law Dictionary is defined as evidence that by itself is sufficient to sustain a judgment. As the plaintiffs have already admitted, this is the evidence that must stand by itself in this case. And according to the statutory definition, that by itself is insufficient to sustain a judgment against the school district. The third rule is more of a rule of evidence. The third rule provides that evidence that a person was or was not wearing his or her seatbelt at the time of injury is, quote, not admissible or shall not be admissible in regard to the issue in regard to the issue of liability or proximate cause. Again, if this evidence, even if it could stand by itself, under section 60-6,273, that is not admissible to prove liability or proximate cause. And I believe there was a question earlier to counsel about how this kind of plays with the Warner case. And the counsel repeatedly refers to this as the, quote, seatbelt defense. It's not a seatbelt defense. Those words appear nowhere in the statutes. These are seatbelt laws. And we can't.
And in Warner, with respect to 273, we said non-use is admissible only regarding mitigation of damages. You got to get to working on damages before you can refer to non-use under that interpretation. Is that correct?
Under 273, under this evidentiary rule, there are 2 sentences in the entire statute. And the first is it's not admissible to prove liability or in regard to liability or proximate cause. And the second sentence says, however, it is admissible for mitigation of damages up to the 5% cap. That however, or that exception to the rule cannot consume the rule. And that exception makes sense when you consider that the case of, I think it's Vredeveld, if I'm saying that correctly, but in Vredeveld, this court considered the mitigation of damages. And the defense there attempted to argue that simply the plaintiff not having his seatbelt on at the time of the injury meant that they were automatically entitled to the mitigation defense. And this court held, well, no, you still need to prove proximate cause. And so it makes sense when we have a complete comprehensive ban on this evidence being admissible for liability or proximate cause, but we have an exception that says you can get a 5% mitigation of damages as the defendant if you prove the proximate causal connection between the lack of a seatbelt and the injury.
Is the wording of that statute a little bit curious in the sense that proximate cause is an element of liability, isn't it?
No, I think it's, well, I guess I would consider it more of a belt and suspenders, Your Honor. I think that it's saying that it cannot be admissible if you think of the four elements of negligence. I would consider the liability to be more of the duty and the breach elements, and proximate cause to come as the third, obviously before damages.
Well,
And
I'm
so-
with Judge Castle.
Okay.
There's a little curiosity. I'm not sure what that means.
Well, I
Assume
think,
for the moment that we would typically say that the formulation of negligence, duty, breach of duty, proximate cause are the elements of liability. What difference, if any, does that make in interpreting this statute?
I don't think it makes, with all due respect, I don't think it makes any difference. I think that Section 273 also needs to be read in with the entire statute, including 269. And 269 has already said, when we're talking about the duty of a driver to have rear minor passengers belted, that duty, or a breach of that duty, or a violation of that duty, is not prima facie evidence of negligence. And so I suppose under a different kind of case where there are multiple examples of negligence, where you have maybe erratic driving or some other contributory cause to the accident, where the plaintiff, as here, where a plaintiff has not admitted that the driver had absolutely no contribution to the accident, then we might be talking about a situation where they're using it for a different purpose. But here, they have no other evidence. There is absolutely nothing in the record to suggest that the driver did anything wrong except for the alleged violation of this duty statute and the seatbelt laws. And that takes us to the crux of all of this. And I think to get back to Chief Justice, you had a question about the legislative history or the legislative intent. And I will echo Mr. Duncan in that there's not a whole lot there. But I think what the legislative intent, there's not even an ambiguity in this statute that gets us there. But if there was, the legislative intent makes it clear, both on the face of these statutes and in the history of the legislation, that this was all done as an effort to create, I guess, as much of a minimum impact of a violation of the seatbelt laws. This was done from the legislative history to comply with federal regulations and to secure highway funding. They made it a secondary offense in the statutes. They said it's not punishable or it's not citable even by the police unless you've done something else wrong on the road. And even then, as a secondary offense, the maximum penalty, no matter if you have 8 passengers back in the back seat that aren't belted or 1, it's a $25 fine and nothing more. It's a quantum leap to go from that minimizing effect of a seatbelt violation by the legislature to now say that you have a maximum liability under the Tort Claims Act. And I want to reserve the 2 minutes for Mr. Kretschy. And if there are no other questions, in conclusion, I'd ask on behalf of the Broken Bow School District that this case be affirmed and that the directed verdict be upheld. Thank you.
Thank you very much. Mr. Krejci, good morning to you.
Good morning. Jared Krejci on behalf of Beverly Sherbeck. She is the personal representative for her late husband. May it please the court counsel. I just wanted to reserve this 2 minutes predominantly to ask if there were any questions about my cross appeal. I concur wholeheartedly with Mr. Riley, and I think he's probably more prepared to talk about the actual seatbelt statutes than I was. But since I filed this cross appeal, and really, since I do believe in Mr. Riley's argument, maybe it was unnecessary to file the cross appeal, but it's incredibly important to Mrs. Sherbeck that there's finality for her after she obtained a defense verdict that was upheld on appeal. And the alternative of if the district court's motion for directed verdict is reversed, then Mrs. Sherbeck, as personal representative, faces involvement in this ongoing case as a third-party defendant brought into the case by Broken Bow Public School. So,
If the case is reversed.
if the case is reversed, then the procedural posture will be the Christensens versus Broken Bow Public Schools with Beverly Sherbeck as a third-party defendant. And that would be in the absence of any type of ruling on law of the case, issue preclusion, or Article 1, Section 6 of the Nebraska
If
Constitution.
the case were affirmed, what's your comment, please?
If the case were affirmed, then the third-party complaint brought by Broken Bow Public Schools against Mrs. Christensen would be moot, because it's an action for contribution or indemnity, and there's no liability.
Thank you.
Are there any other defenses out there that have not been handled by the trial court?
Could you rephrase your question, Your Honor? I'm not sure if I understand.
I'm not sure. I guess I was asking about the procedural process. When it was sent back down before, we said, I think we said, take care of the other defenses, and we seem to be concentrating on a defense. Are there any other defenses out there that the school district might have?
There are factual defenses. So if you affirmed the district court's order, presumably trial would resume with all three parties, and
You mean if we reverse?
if you reversed, I'm sorry. If you reversed, trial would resume with all three parties, and we'd go back and we'd be on the two defendants' cases. And at that point, the district court judge would first have to make a decision on the school's liability, which could go either way. And if the district judge found that the school was liable, there is this potential third-party indemnity or contribution claim against Mrs. Sherbeck that it's my opinion that there are legal doctrines that prevent that claim that have not been ruled on by the district court. But it's incredibly important to me to try to prevent Mrs. Sherbeck from having to go back into a trial. All right, I have exceeded my time, so thank you, Justices.
Thank you very much. Do we have any time for rebuttal?
No, Your Honor.
There is no time for rebuttal, so that concludes arguments in Christensen versus Broken Bow Public Schools. Counsel, thank you very much. You are excused, and the court will go on to the next case of the day, which is State versus Galindo. I am recused from this matter, and Justice Frydenberg is recused from this matter. So Judge Stratman will continue to sit with the court, and Judge Burns, also of the Douglas County District Court, will join this court, and Justice Miller Lerman will preside. So please give us a moment to get in and out of the courtroom.
Thank you very much. Counsel can be seated. And Judge Burns is going to join us. And then for record purposes, I will call the case, so it'll be part of the file on this case. All righty. Good morning.
Good morning.
Thank you. The next case on the call is State versus Galindo. The Chief Justice is recused, Justice Frydenberg is recused, and sitting with us are Judge Burns and Judge Stratman, and counsel can proceed. Thank you. And for housekeeping, I think the argument is now 15 minutes aside. Any wrinkles to that, or are we good?
Could I reserve 5 minutes, Your Honor?
The clerk will reserve 5 minutes. Thank you.
Thank you, Justice. Good morning. May it please the court. I'm Adam Sipple. When Mr. Galindo's sentencing case is assessed and evaluated consistent with the law and consistent with the Constitution, his youth, his confession, his cooperation, and his demonstrated remorse provide a strong case to spare him from execution. A reasonable jurist could find, based on those circumstances, that the record doesn't reflect the type of extreme culpability making him one of the most deserving of execution.
That's reflected by the prosecutor's letter on October 31, 2002 to defense counsel for Mr. Galindo, expressing his belief that he was the third most culpable with respect to the bank robbery and maybe didn't deserve the death penalty. And Mr. Galindo's argument for life is the reason the prosecutor filed the aggravating circumstance regarding the Travis Lundell homicide. It's the reason he manufactured the jailhouse testimony to prove that allegation. It's the reason that the sentencing panel relied upon that allegation 3 separate times to justify imposition of the death penalty. And it's the reason why this court cannot find beyond a reasonable doubt that consideration of the Lundell aggravator did not influence the sentencing panel in making their sentencing determination.
May I interrupt, and then maybe you will tell me this is not a good question, but if all of the Lundell material was excluded, where would you find yourself in terms
Justice,
of
that's
aggravators?
exactly what I want to talk about today. So the state's argument below, adopted by the district court, is to just ignore all this about the prosecutor, ignore all this about defense counsel, ignore the way the record looks with respect to the Lundell allegation, take it off the table, and find that the sentencing panel, we'd have to find it beyond a reasonable doubt, but find that the sentencing panel would return the same sentence nonetheless. Here's the problems with that argument. And frankly, it's no better than the arguments made by the state the first 2 times this case has been before the court. The most important point I want to make today starts with the fact that the arguments and the claims made by Mr. Galindo, if proven and accepted, would change the sentencing balance 5 different ways. They talk about it in terms of just removing the 1A Lundell aggravator and going on from there. Then they ask you to reference the Sandoval case, which of course violates every principle of individualized sentencing that's ever been written in the law books. That's their argument. But the fact is, it changes 5 ways based upon the claims made by Mr. Galindo. First, the Lundell aggravator would be invalidated. Second, the instruction regarding the exceptional depravity, especially heinous aggravator, renders that invalid. That would be removed from the aggravating side of the scale. So 2 aggravators, not 1, 2 aggravators would be removed. And on top of that, over on the mitigating side of the scale, we would add consideration of youth, which we'll talk about today, I hope, constitutionally required to consider my client's age. We'll add the evidence of demonstrated remorse that defense counsel left in his file. So we add 2 mitigators. And then we add a 3rd mitigator because based upon the supposed lack of remorse, the sentencing panel discounted Mr. Galindo's cooperation, which frankly put his life in jeopardy and should have earned him significant credit. And so a reasonable jurist in this case could easily find, if Mr. Galindo's claims are proven after an evidentiary hearing, that the mitigators approach or exceed the weight of the aggravators.
You said that we would have to find that if the aggravators were taken out and the mitigators you're relying on were added back in, beyond a reasonable doubt that they wouldn't affect the determination.
That's correct. I'm sorry.
The district court relied on a different standard, correct?
That's true. The district court standard, frankly, is unclear. First, it refers to the Sandoval case, which is inappropriate. Second, it talks about whether it would be futile to remand it for resentencing. It also explicitly reweighs the aggravators and mitigators.
Well, assume that what the district court did was apply sort of the second prong of Strickland as it relates to ineffective assistance of counsel, or the third prong of Brady as it relates to a Brady violation or prosecutorial misconduct in general. I mean, isn't that standard not the harmless error standard of beyond a reasonable doubt, but a reasonable probability of a different outcome?
Those are the correct standards. Reasonable probability on Brady, undermining confidence in the outcome. I think that standard would be applied
to determine whether that aggravator should be invalidated. Once it's invalidated, you apply the higher standard, which is what the state recognizes, which is a very difficult standard to make, harmless error beyond a reasonable doubt. With respect to Lundell, there are, of course, the court knows, myriad allegations, very specifically, very thoroughly, very persuasively pled. Hard to imagine that those wouldn't undermine confidence in the verdict of the Lundell.
I'm not sure I understand exactly where you're going. I mean, we'll take ineffective assistance of counsel first, and assume that you've adequately alleged with respect to the Lundell aggravator. Assume that you've adequately alleged some deficient performance by counsel. Wouldn't we then have to ask, well, is there prejudice? And isn't the question of prejudice not harmless error beyond reasonable doubt, but a reasonable probability that the outcome would be different?
No, you're absolutely correct, Justice. And I'm just trying to narrow the argument. I'm trying to address what they've raised. Their argument is they don't address that. They go straight to the next step, which is the harmless error standard after the aggravator is invalidated. The problem is we're way ahead of the game here. The process is the allegations create legitimate issues. You grant an evidentiary hearing. You try those issues. You make findings on them. And you would make findings on them using the standard that you have, Justice, articulated.
But you wouldn't grant an evidentiary hearing if, even assuming the deficient performance was adequately alleged, there's no way it would amount to prejudice, correct? I mean, what would be the purpose of the evidentiary hearing if any attempt at proving prejudice would be futile?
I suppose there could be a case where that would be the situation. I can't imagine how that would be the case here. I would note that the state hasn't argued that, in my view. I would note that the district court made no real specific findings on how that could be true, as you see in some other cases. Both the district court and the state have gone straight to the harmless error standard that's applied under Sandoval and Reeves 4. And so if you look at the 1A aggravator, the way that analysis is conducted, the way it was conducted in Sandoval, is that you look to the findings of the sentencing panel. You look to the sentencing panel's order. And when you do that, in this case, you can't find anything that supports a finding beyond a reasonable doubt that they would have reached the same decision for a number of reasons. First, they find that each of the aggravators is significant and substantial. And I know this court relied upon that finding in Sandoval, but it's different here. Here, the Lundell aggravator obviously is potentially a thumb on the death side of the scale. Very significant aggravator. The idea that Mr. Galindo's alleged involvement in a precedent homicide didn't drive the sentence in this case is hard to fathom. Sentencing panel doesn't say otherwise. And they do say that with respect to the 1D aggravator, with respect to the especially heinous instruction. So with respect to that issue, they did find that even if they didn't consider that aggravator, they would return the same sentence. So it's like a legislature. They knew how to do it. They demonstrated their ability to do it. They declined to do it with respect to the 1A aggravator.
Were there potential questions of constitutionality with respect to 1D that might have caused them to speak particularly about that in a way that they wouldn't with others? I mean, is that fair?
Well, they were aware of the concerns on the 1D aggravator, Justice, you're correct. And so they did have reason to do that. They didn't know all the circumstances surrounding the Lundell aggravator. But nonetheless, that just leaves the court in a position where it has to guess and speculate as to what it would do. Just like in Reeves 3, when the issue of intoxication was not considered or perhaps not raised, and the court found that there's no way to determine what the sentencing panel would have done if they would have considered intoxication. No way to determine what their sentencing decision would have been. I want to just quickly, even though I'm in my time, two real huge issues that I think are just plainly meritorious in our favor is the issue of failing to introduce the evidence of remorse. That's defense counsel's primary duty, is to
introduced mitigating evidence. That mitigating evidence is without doubt, it's not of any dubious character. It's in sworn deposition testimony. It comes from a law enforcement captain as well. You know, you can hold it, mark it as an exhibit, and introduce it. Instead, it was left in defense counsel's file. That is a constitutional violation. It affects the sentencing analysis, and it has to be addressed. Secondly, youth. When I saw that in the record and I started talking about it, I kept waiting for the state to say something about why I'm wrong. I kept waiting for the district court to say why I'm wrong, that somehow it was okay for defense counsel not to introduce more persuasive evidence about the age of Mr. Galindo, and why it's okay for the sentencing panel to say that we're explicitly refusing to consider age as a mitigator. And I haven't heard it. The state hasn't addressed it in a brief. The district court didn't address it in its order. To me, that is a plain constitutional error that affects the sentencing analysis.
Is there case law from this court that age relates to not young offenders but old offenders? And how does that impact it?
There is authority. It's State versus Lauder. Lauder cites a case that was decided before the Supreme Court cases, the U.S. Supreme Court cases that recognize age as a mitigating circumstance. So it just needs to be readdressed. The cases cited in the brief make it super clear that age is a mitigating circumstance. May I reserve the rest of my time?
Please.
Thank you.
Good morning again. James D. Smith, Senior Assistant Attorney General, appearing on behalf of the appellee of the state of Nebraska. First thing I want to say is the law is clear that post-conviction relief is a very narrow category of relief, available only to remedy prejudicial constitutional violations that render a judgment void or voidable. A couple other things I want to mention. Galindo's reply brief relies upon misstating the holdings of both the United States Supreme Court in Clemens and this court in State v. Reeves. In Clemens, the U.S. Supreme Court held that harmless error can be applied by state courts in capital sentencing, including harmless error reweighting of aggravating and mitigating circumstances, and harmless error in relying upon an erroneous aggravating circumstance. Galindo's reply brief cites Clemens for the opposite proposition.
In the state's view, do we even get to harmless error, or is this resolved on the prejudice element of Strickland and Brady?
Ineffective assistance of counsel would be resolved on the Strickland prejudice standard. And I know I cited in my brief the Supreme Court in a capital case in Strickland, specifically holding that there is no possibility the claimed additional or mitigating circumstance would have changed the conclusion that the aggravating circumstances outweighed the mitigating circumstances. So Strickland itself goes to the prejudice isn't there.
So if we're analyzing this under Strickland and we assume that we have deficient performance with related to, say, the Lundell aggravator and the other mitigators counsel mentions, remorse and youth, is what we're looking at. If those mitigators are added in and the Lundell aggravator is taken out, is there a reasonable probability of a different result? Is that the Strickland analysis?
That would be the Strickland analysis that the claimed, and then it comes down to the claimed additional or mitigating evidence would have changed the conclusion.
But that's not harmless error, right? That's a different...
That's Strickland's constitutional prejudice analysis. There's an important point to make in your assumption, though. As far as the age of the defendant, the district court at the time of its sentencing specifically rejected the age of the defendant at the time of the crime. That's on page 8 of the district court's sentencing order. The district court specifically rejected in its sentencing order any concept that this remorse idea would somehow spare him on mitigation, because on page 7 of the district court sentencing order, the district court specifically said, following his arrest, the defendant planned an escape from jail without any participation by Jose Sandoval, which escape would have involved violence if necessary. That would, the rejection of mitigation on those two things I've said would reject the idea that this age of the defendant and maybe some remorse is somehow going to be sufficient to overweigh the aggravating circumstances that were found. Even if you take the Lundell out,
I
you
beg your
still
pardon,
have
the
4
material
left.
that you just quoted, is that like a finding of fact, or is that a narrative?
The material I'm quoting is, the court bases that finding on the following. It's a finding.
It's a finding.
Of the
It's not a
sentencing-
pigeonhole of a specific aggravator, much less a
No,
mitigator.
it's a specific finding
Thank
by the district court at the pages I cited in the
Thank you.
sentencing order. I would also point out that the idea that the Lundell aggravator just disappears, you need to look at the district court, which noted that the fact Galindo led law enforcement to Lundell's body, the 6th murder victim, shows no prejudice anyhow for aggravator 1A. That's at page 220 to 221 of the district court's post-conviction order. So the district court is going in the alternative that even if we take the Lundell aggravator out, we still have no constitutional prejudicial error, but the district court doesn't concede that the Lundell aggravator disappears when we have the fact that the evidence shows Galindo, from the trial record, led the investigators to Lundell's body, which then has the district court saying the rest of this by a bunch of these jail informants and everything is just cumulative evidence. So I don't think, at least the way the district court entered its order, that it's necessarily that the Lundell aggravator is out, but even if it is out, the district court still concluded that it would be basically futile to have a post-conviction hearing when there are 4 other significant and substantial aggravators against one non-statutory mitigator, and per Strickland v. Washington, no reasonable possibility that the claimed additional or omitted mitigating evidence would have changed the conclusion that the aggravating circumstances outweighed the mitigating circumstances. In short, if you go in and murder 5 innocent people, saying that, gee, I shouldn't get the death sentence because I really didn't kill the 6th, that doesn't really indicate a prejudicial error in the sentencing that would justify having a futile evidentiary hearing just for the purpose of saying, gee, was the sentencing order incorrect in sentencing him to death?
Is this comment or argument that you've just made essentially that which the appellant seeks has already been done? That in the sentencing order, if Lundell's out and youth and remorse are in?
In the sentencing order, to me, those findings by the district court would reflect having an evidentiary hearing on age doesn't make any sense when the sentencing order rejected the age.
Has encompassed those things the appellant seeks?
Yes. He already got the benefit of that when he got sentenced and the district court rejected it.
Thank you.
So why have another evidentiary hearing when the record affirmatively rejects the concept that those, what I would call non-statutory mitigators, are going to override what we have as 5 or 4 statutory aggravating circumstances.
This is perhaps ignorance. Is not Lundell a previous crime if it were established to the right degree of burden?
Well, Lundell would fit under, when you look at...
Is it a statutory aggravator?
It would fit under as a statutory aggravator under 1A.
Okay.
defendant
That's
has a
maybe-
substantial
Right.
prior history.
So it could impact an aggravator under 1A
Yeah.
as found by the sentencing order.
That's
Is that correct?
but not the others.
Thank you.
Do we need to look again at how we have defined age as a mitigator? I understood that to be
not-
a suggestion made during your opponent's argument.
Not in the context of retroactivity, where the defendant is trying to say that, gee, if age somehow later came into the constitutional analysis by some subsequent U.S. Supreme Court decision, which has never said that's retroactive, the answer to that would be no. There's no, you're looking at prejudicial constitutional error as of the time the defendant was sentenced.
What did the sentencing panel say about age?
I can find it. I'm getting old enough I can't read without my glasses anymore. Sentencing panel says, as far as the mitigating factor, the finding, sub D on page 8 of the sentencing order, the age of the defendant at the time of the crime. Defendant was 21 years of age at the time the murders were committed. Cite State v. Lauder that the Supreme Court interpreted the language of the statute, it's not the Constitution, interpreted this language to refer to a person of advanced years whose personality may be involved. Defendant is not such a person. Panel finds there is no evidence to support the existence of this mitigating circumstance, concludes it does not apply. So the factor of age was addressed, was considered by the sentencing panel, and was specifically found that it did not apply as a mitigating factor. The sentencing panel does acknowledge he's 21 years old, does point out that the defendant presented psychiatric testimony about the defendant having some psychiatric issues and everything else. The sentencing panel pointed out that the state also contradicted that, and the sentencing panel specifically rejected the defense presenting this evidence of the defendant's mental capacity, mental impairment, and all of that, and in the context of the defendant being 21 years old, it also rejected age. Trying to come in and show a prejudicial constitutional violation, it's not statutory, it's constitutional violation, where you're trying to apply something retroactively to what was not constitutional error at the time, is simply not the way it works. The ultimate issue I would submit to this court is, can this court, like the district court, conclude upon review of the trial record, Galindo's amended post-conviction motion, that the sentencing panel would have imposed 5 sentences of death, even in the absence of consideration of aggravator 1A, the Lundell murder, and the claim mitigating evidence that they're now claiming. And I would submit it's a de novo standard of review. On de novo review, like the district court, there was no prejudicial constitutional violation in Galindo's death sentences, and thus the district court should be affirmed. And what the district court, I rely upon what the district court entered for an order and signed. It's fairly extensive, has good findings, conclusions, citations to the law, and frankly, the way I submitted my brief is the district court on de novo review that order. It's not, there's no error.
Mr. Galindo argues that the allegation that there was a conflict of interest on the part of the prosecutor is structural error that wouldn't be subject to any harmless error, prejudicial type review. What's your response to that?
He doesn't have any precedent to support that. The structural error comes in the context like chronic on ineffective assistance of counsel, saying that it's somehow a structural error overrides the fact that you're supposed to there's just no precedent that Brady errors somehow become structural errors when this court itself has said when you apply Brady, you still have to satisfy the prejudice
But
component.
under chronic, that, if I'm perhaps wrong, would say prejudice is presumed.
Prejudice is presumed in the context of a constitutional claim of ineffective assistance counsel.
Right,
It's not a Brady error.
Right, a pigeonhole, perhaps a small pigeonhole.
I'm sorry?
A small pigeonhole where prejudice is presumed.
It's a very small one. I know I argued prejudicially years ago, or
Maybe I was there.
no, I argued presumptive error, in which I remember Justice Connolly says the state never gets up and says that to us, and I did that once, but this isn't the case. Okay. I don't know, are there any further questions I might be able to help with?
Questions?
Yeah, I would say my brief was short. I thought it was appropriate to be short because I wanted to tell the court, look at the district court's order. It's not de novo review of my brief, it's de novo review of the district court's order. Thank you.
Thank you. How much time does Mr. Sipple have, please?
2 minutes and 53 seconds.
Thank you.
Thank you. May I proceed?
Please.
What Clemens and Reeves say and how they've been characterized in my brief is that Clemens allows harmless error review, but it doesn't allow independent reweighing by this court. It doesn't allow this court to independently assess the facts of record and the circumstances and kind of act as a secondary sentencing body unless given legislative authorization to do so. And this court concluded in Reeves 4 that legislative authority is absent, such that this court cannot get into any of those circumstances that Mr. Smith has suggested with respect to maybe trying to escape from the jail or things like that. It is limited to looking at the sentencing panel's order and deciding whether from that order they would find the same thing. That leads me to the next point for Justice Papik and Justice Miller-Lerman. I want to be real clear about what the district court did and what it didn't do. Its harmless error analysis, and it's, I think, confusing whether it's under the Brady and Strickland standards or whether it's under the Clemens and Sandoval standards. Either way, it's limited to removal of the Lundell aggravator. It never addresses adding consideration of youth. It never addresses adding consideration of the evidence of remorse. It never addresses what the sentencing panel would do if they found there was demonstrated remorse. Would they give him full credit for cooperation? And so there are 3 mitigators on the balance, left off the balance, whatever, part of the mitigating side of the balance, that the district court has never addressed. Likewise.
But we review it de novo, right? So whether the district court reviewed it or not, it's up to this court to review it.
Sure, you could review it de novo, Justice, and conceivably you could find beyond a reasonable doubt that they would have returned the same verdict even if they hadn't considered the explosive Lundell homicide, even if they hadn't considered the especially heinous and exceptional depravity aggravator, and even if they had considered his youth, and even if they had considered his remorse, and even if, because they considered his remorse, they're going to give him full credit for his life-endangering cooperation. Yes, you could review it de novo and you could make that finding. I would ask you not to. That ends my time. I appreciate it. I would ask this court to reverse this case for evidentiary hearings, which we haven't discussed. There's a whole bunch of cases that say that under these circumstances we get an evidentiary hearing. That's my request. Thank you.
Thank you very much. That concludes arguments for today's session. We're adjourned. You're all excused. Thank you.